Good afternoon, Your Honor. Omar Shah on behalf of the people, PH 6332.
Good afternoon, Your Honor. Edward Taylor, P571166, appearing on behalf of Mr. Spencer. Mr. Spencer, will you introduce yourself to the court, please?
It's never a good sign when the first thing a judge says is that they were moments away from signing a warrant. That sets the mood fast, and not in a good way. Mr. Spencer isn't just towing the line. He's practically balancing on it, and if it hadn't been for his lawyer physically showing up with him in tow, we might be talking about his appearance in court from behind bars. Now, let's be clear. This wasn't a simple case of hitting snooze one too many times. This court isn't known for its patience, and it's definitely not in the business of handing out freebies. Every decision here counts. The room is tense, the expectations are strict, and the consequences very real. So sit tight, because this hearing isn't going to be smooth sailing. It's shaping up to be one of those courtroom moments you don't forget anytime soon.
Okay, Mr. Spencer, you were supposed to have been here this morning. Lucky for you, your attorney was willing to go pick you up because I was issuing a warrant.
Picture this for a moment. Your attorney has to stop everything, leave their office, jump in a car, and come knock on your door just to get you to court. That's not loyalty. That's not generosity. That's damage control in motion. A last-ditch effort to prevent you from landing in even deeper trouble. This isn't standard legal practice. It's a red alert. Judges don't usually sit stunned in silence, but in this courtroom, even the bench was taken aback. What we're witnessing isn't just poor planning. It's a complete disregard for legal expectations. And make no mistake, that kind of behavior can spiral fast into serious consequences. And here's the real takeaway. If you're supposed to be in court and you're still lounging at home, that's not a power move. That's a red flag waving loud and clear, and the system doesn't miss it.
So why were you just hanging out at your house and not here at the court?
Well, I did go on the Zoom this morning, but it was difficult to do.
Okay, so I will acknowledge that I did see you in the waiting room on Zoom. We've been having issues with people impersonating names on Zoom and submitting inappropriate videos. So I will acknowledge, counsel, that I did see your client's name in there. I have no way to know if it was him. And as you can tell, I was a little hesitant to invite some people today. And
I've seen the video, Your Honor. Judge King showed me some of his.
oh yes, Judge King gets some, he gets some doozies also. Okay, so, but then sir, when you were having difficulties, did you contact the court?
Let's unpack what really happened here. This was meant to be a routine Zoom appearance, nothing complicated. The court even provides these remote options to keep things simple for everyone involved, especially for quick sessions like a probable cause conference. It's supposed to be easy, but here's the reality check. Zoom is a convenience, not a get-out-of-court free card. Just because you're appearing virtually doesn't mean the expectations are lower. And if your tech fails, whether it's your camera, audio, or Wi-Fi, the court isn't going to sit around waiting. They're not troubleshooting your connection. They're moving forward. The judge made it loud and clear. If you can't be there online, then your next best option is to get there in person. No signals, no screenshots, and definitely no excuses. The justice system runs on accountability, not connectivity.
Okay, absolutely you should have. Or you should have somehow found your way here into the courthouse, right? So the court allows individuals and attorneys to handle the PCCs by Zoom because those are generally pretty quick, right? And a lot of times attorneys have multiple PCCs at one time. So courts aren't all waiting on the same attorney. This court and other courts allow individuals and attorneys to appear by Zoom for PCCs. That doesn't mean that's the only way to appear. So if there's technical issues, you need to be in person, okay? All right. So I'm on the lecturing for the day. Counsel?
Yeah, I indicated to Mr. Spencer's statutory right for a preliminary exam in this matter. At this time, he wishes to wait.
Okay. And Mr. Spencer, you've heard everything that your attorney has indicated, correct?
Yes.
All right, And so you do understand that you do have the right to have a preliminary examination where it must be shown that a crime that's committed for probable cause exists to charge you with that crime. You also understand that by waiving your right to a preliminary examination, that your matter will be bound over to circuit court on the charges in the complaint warrant, correct?
Yes.
And has anybody promised you anything, threatened you, or coerced you in any way for you to waive your right to your preliminary examination?
This is a big moment. Mr. Spencer is waiving his right to a preliminary exam. That's the hearing where prosecutors have to show there's enough evidence to justify a trial. By skipping it, the case jumps straight to circuit court, where things get more serious. The judge isn't rushing this. She's taking her time, double-checking that Mr. Spencer knows exactly what he's doing. No pressure, no deals, no confusion. Just a clear statement, under oath, that he's choosing to move forward with that waiver. The case officially steps into the next phase, and there's no turning back.
All right, and the court will note that examination having been waived, defendant found over circuit court for further proceedings. You are to appear in circuit court on October 5th at 9 a.m. on the charges of the complaint. All right, anything else, counsel?
No, Your Honor.
All right, bond and conditions are continued. Mr. Spencer, if you were to test today, what's in your system?
Alcohol.
Alcohol. You were consuming it today, weren't you?
Yes.
Yes, okay. So, so here's what I need to know. Now that I've accepted the waiver, are you under the influence of the alcohol?
No, not more than that, no.
Not, what does that mean?
That's all.
What?
It's not much sleep, that's all.
Okay. Counsel, I'm going to have a PBT administered to your client just to make sure that your client...
Whoa, did Mr. Spencer just say he's had something to drink today? That's a huge issue, especially in court. The judge catches it instantly. When someone waives a legal right, they need to be fully aware and mentally clear. Admitting to drinking calls that into question fast. To be sure, the judge orders a PBTA, a breath test, to confirm whether he's sober enough to move forward. This isn't just protocol. It's about making sure justice is handled responsibly and fairly.
Not intoxicated to enter into this waiver. Okay, so let's go off the record for a moment. And then we need a PBT. Gordy, can you ask the PD if they can bring over a PBT real quick, please? Thank you.
Your Honor,
Hello, yes,
or this gentleman?
Yes.
Okay.
thank you.
What you're gonna do here is just you can hold this, just grab it and blow with one long continuous breath until it stops speaking, okay? You gotta give, you don't have to push anything, just blow into that straw. All triple zeros.
Okay, thank you. Okay, I just wanted to confirm, since you did indicate you consumed alcohol this morning, I wanted to make sure that you were not still under the influence of alcohol, since we accepted your waiver. Although it's not lost on the court that you're not supposed to be using alcohol anyway, since that's one of the conditions of your bond. So what gives?
What happened again, Your Honor?
Oh, we're back on the record, right, I'm sorry. Well, sir. Okay, but why are you consuming alcohol when you're not, when you're ordered not to?
I know it's just that. I say what happened to me.
All right, counsel, I think that, I may amend the bond condition to include an alcohol tether for your client. I initially did not do that, given his charge, but it appears as though that's also a concern.
Cool. And now the fallout begins. After admitting he'd been drinking, the judge adds new terms, random drug and alcohol testing. It wasn't required before. But now the court sees a clear red flag. What was supposed to be a routine hearing just got real. Mr. Spencer's walking out with tighter rules, more conditions, and a judge watching every move. Oh, and those tests. No warning, he won't see them coming.
Right now he was. I'm not going to do the alcohol test. I'm going to indicate you have to submit to random testing, sir. So bonding conditions are continued. You have to submit to random testing. So you don't know when you're going to get called for testing, so make sure that you are not consuming any alcohol or drugs. They're not prescribed. Okay, and anything else?
No, you got it.
Again, thank you, Mr. Taylor, for going and picking up your client. And sir, please stop over at probation. Do not leave without going to probation. You're not on probation, but they will give you the information about testing.
All right.
All right, thank you.
Thank you.
Okay. Thank you.